everybody, it's attorney Veronica McClendon, and I wanted to come and talk to you about a question that I got asked within the past couple of days. In fact, there were two questions that I was asked and they were related, so I figured I would go ahead and talk with you all about it in this video. So the first question that someone asked me was, do I really need to hire you as a lawyer to do my will, or can I go online and do it myself? And I explained to this person that yes, you can go online. There are plenty of resources online that you can use to do your own will. However, you don't know which one is going to be the best one for you. That's the first thing. That you don't know which platform is actually going to help you accomplish your goals. You don't know if the platform that you are using actually is going to be using the current state laws or not. They may tell you that they are, but you don't know for sure. And of course, if you're talking to a lawyer, you don't know for sure if we know either, but at least if things don't go right, then you can have some recourse with the state bar because we are obligated to make sure we are competent and ready to take on a case. So if we don't know what the current law is, then that's something that we're held accountable for. But I can't say the same for these online platforms. I don't know them, so I just can't say the same for them. Another thing with this client, they asked me specifically, can I do my own will online or do I need to have you to do it for me? And one of the questions that I asked them was, are you sure that you need a will? What about if you need a trust? What type of trust is going to be best for you? So that's where a lawyer comes in because we can hear about your situation, hear all of the facts and the details about what you are wanting to accomplish with your estate planning, and then we can advise you on what we would recommend that you do to help you accomplish your goals. People who have programs online, they may have an idea of what kind of goals they think you need to accomplish, but we want to make sure that we are creating an estate plan that's going to help you accomplish your goals. So with that being said, having a real live lawyer that you can explain your situation to, you can tell them about your family, you can help them to understand all of the things that you own. Once you have a real person in front of you, they can help you to come up with a plan that's actually going to help you to accomplish the goals that you have and help you come up with different alternatives that you might consider to help you to really come up with a plan that's going to be appropriate for you and your family. So that was the first question that I was asked. Do I really need a lawyer to help me with my estate planning? And like I said, they really said will. So with the lawyer, you're able to learn that it's not just about a will. It could be a trust that we want to do. We can also talk to you about powers of attorney, healthcare directives, and how to make sure that you put the right people in place to handle either of those things for you. The second question that I get asked a lot and that I was asked very recently is, do I even have to have a will or an estate plan? Can I just tell my family what I want? Can I tell them who I want to be in charge and how I want everything to be divided up? And the answer to that question is yes, you can tell them what you want them to do. First thing is, are they going to listen? If they have you telling them when you're living and then now you're gone and you're wanting them to still honor your wishes, they may not do what they said that they would do when you were alive. And it doesn't always have to be a malicious reason. Sometimes things come up. Have you ever been in a situation where perhaps you were holding something for someone? You maybe had some money for them that you're holding for them, taking, just handling things. Sometimes those things come up where you have this sum of money that's in your control, but then now a bill has come due or someone has gotten sick and you're like, well, I had this money and I know it's not mine, but maybe I'll go ahead and use a little bit of it to pay for this thing and then I'll pay it back later. If you've never been in that situation, good for you. Not everybody has been in that situation, but you can imagine how it could come up. So imagine that you tell your children, I want you to do XYZ. And then when the situation comes up, when it's time for them to actually accomplish that, they might have something that has happened that makes them decide they want to do things differently than what you initially said. And then also, things happen where they might not be the only person who's making decisions at that time. There could be a divorce going on. You might say, I want my children to get this property from me, but then now they're in the midst of a divorce and the things that you're giving to them are now subject to that divorce proceeding. Whereas there might be situations where you can segregate that and keep it separate, so that it does not become part of any potential divorce proceedings. There might also be situations where you decide that you want things to go a specific way, and the people who are responsible for carrying it out may decide that they don't actually think that's the best thing to be done. So, for example, you might have 3 children, and you say, I want one of my children to get the house, and I want y'all to split the bank accounts, and I want this other child to get this car, and whatever it is you might have in your plans. If you don't put it in writing, in a legally binding writing, the other kids might decide, you know what, we don't think so and so needs to have the house. Or I actually want this car and not the other car. So now we're going to fight about it because I don't want the one that mama gave me, or that mama said is mine, or that daddy said is mine. I want the one that they said is yours. So if that comes up and you have a will or a trust in place, everybody who is supposed to get something under that will or trust is going to get what the will or the trust says, unless it's contested or something like that, or against the law. There are little exceptions, but not many. But if you just tell people what you want them to do, and then they're in that situation where they have to carry it out, they may not do it the way that you think that they should do it. So that's why it's important to put it in a legally binding document, like a will or a trust, so that your wishes are not just wishes, but they actually are requirements. Another thing that could come up is that things happen where, let's say, I'm trying to think what I'm trying to say here. I was flowing, and now the juices are kind of paused. But I guess what I'll just say is things may happen in the future that you cannot predict now. And so having your estate plan in place, saying who you want to get what, who you want to be in charge, you get to be in the driver's seat about what happens. You could tell your child, hey, I want you to be in charge of this thing, but then they could be facing a lawsuit when it's time for them to take over. And now, I'm just saying, it's a lot of stuff that could happen. I'm starting to ramble, and I'm probably losing y'all, but what I'm saying is that having a will or a trust is the only way to put in legally binding writing what you want to happen with your estate plan. When you rely on what you've told people, sometimes people's memories get foggy and they can't even remember what you told them to do. When you're relying on people's memories, when you're relying on people following your verbal instructions, verbal instructions are not going to be enforceable in court. I think that's what I was trying to say earlier, that you might say that this is what you want to happen, but the courts are going to look at state law to determine what should happen if you don't have a will or a trust in place. So if you don't want state law to take over and determine how things are going to go, you need to be able to tell your family members in a legally binding document like a will or a trust. Another thing that I wanted to mention, if it doesn't leave my mind, y'all, I was supposed to do this video in the morning, and now it's the end of the day. My brain's a little foggy now. But what was I gonna say, y'all? I had it. Anyway, if it comes up, I will put it in the description for this. But it's important that you have a legally binding document in place. And I think what I was gonna say is that we don't know what state law is going to be in the future. It could be done in a way that's favorable to you, that's favorable to your children, or it could be in a way that's not. The only way to pretty much ensure that the wishes you want to be carried out are going to be carried out is for you to create your own will, your own trust, so that you have those things in place. So before I forget anything else, I'm going to stop this here. But I thank y'all so much for tuning in, and I hope it was helpful. If there's any other questions that you have, put them in the comments below, and I will do another video or respond to your comments. I'm going to be doing this every day now. So I will look forward to talking with y'all more about estate planning, probate, heirs property, whatever comes up, whatever you want me to talk about, we'll talk about it. Y'all take care.